Welcome once again to Lehto's Law. Here's Steve Lehto.
Nick sent me notes. So Steve, check out this story from Ohio. And this case, which I have in my hands, is 12 pages long. So this video might run lengthy, for which I apologize now, but it's a fascinating case. And the case is called Ohio versus Diaw, D-I-A-W, I think. I may be mispronouncing the name, for which I apologize, but it's 4 letters, D-I-A-W. And it's an important case because it addresses the Fourth Amendment. But this is from the Supreme Court of Ohio. So as of right now, this would be the law established in Ohio, but not necessarily anyplace else. This could, however, be taken higher because of the fact that it is a Fourth Amendment case. So in this case, we consider whether a person who voluntarily shares location data points with a third-party online marketplace app has a reasonable expectation of privacy in that information. Because a person generally has no expectation of privacy in information that is voluntarily shared with third parties, we hold that the Fourth Amendment does not require law enforcement to obtain a search warrant before securing historical location data from a third party. Therefore, we affirm the lower court's judgment and remand this case to the trial court for proceedings consistent with this opinion. So there's a company called Lehto. They're an online marketplace app that allows users to post items they have for sale. Sounds a lot like some other sites too. It also lets users message each other so they can coordinate a time and place to meet and complete the transactions. Now, the allegation here is that the named party was in an agreement to buy a MacBook Pro laptop from a seller on Lehto at an agreed meeting location to exchange, in essence, money for a laptop. Now, the police kind of figured out who some of these people are, but at one point, a person entered another person's car to buy the laptop, and after the victim entered the vehicle, the guy in the car stole his iPhone and money and also grabbed the laptop and attacked the guy. So the victim exited the vehicle. There was a fight that took place in the parking lot, and as you can imagine, these are all crimes, okay? So, at some point or another, the police got involved, and there is a law in Ohio which allows law enforcement to subpoena witnesses after a felony has been committed, but before any arrests have been made. So, a detective subpoenaed Lehto for the names, addresses, phone numbers, IP addresses, and email addresses associated with the customer using the name of one of these aliases. And specifically for the posting of the sale of a MacBook Pro for sale through Lehto, posted in Columbus, Ohio, between the dates of February 16th and 18th of 2020. Lehto gave all the information over to the detective. IP address, email address, latitude and longitude points associated somehow with it. And according to the detective, the latitude and longitude points correspond with a restaurant which is adjacent to an apartment that the named person has. Okay? So apparently arrests were made and so on. And at one point or another, that person moved to suppress the information that Lehto provided in response to the subpoena. And as you can imagine, without information, they couldn't have got him, so this whole case would go away. The trial court granted the motion, finding the police had acquired the information in violation of the Fourth Amendment, but the 10th District Court reversed, relying on the U.S. Supreme Court decision in Carpenter v. U.S. from 2018 to hold that the man here did not have a reasonable expectation of privacy in his location data because police obtained only a single voluntarily communicated data point that was historical in nature and was not a real-time location or his home. So the man here appealed to this court, arguing that he had a reasonable expectation of privacy in the location data his cell phone communicated to Lehto. So the court agreed to review a single proposition. The question is, does the United States Supreme Court holding in Carpenter and related cases hold that individuals maintain a privacy interest and Fourth Amendment protection in the whole of their movements, including their physical location? So the court goes into what the standards are. keeping in mind that the Fourth Amendment guarantees the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. And there are things about protections against arbitrary intrusion by the police, etc., etc. The Fourth Amendment stays the hands of the police unless they have a search warrant issued by a magistrate on probable cause supported by oath or affirmation. A search occurs in violation of the Fourth Amendment when the government gains evidence by physically intruding on a constitutionally protected area, or when the government's intrusion violated a person's reasonable expectation of privacy. So until the middle of the 20th century, the court's Fourth Amendment jurisprudence focused on whether the government trespassed on a person's private property. Later, the court recognized that in addition to protecting private property, the Fourth protects against governmental intrusion when two criteria are met. First, the person's exhibited an actual expectation of privacy, and second, that the expectation is one that society is prepared to recognize. And that, of course, is the Katz case. Katz, K-A-T-Z. Put differently, a defendant must show that his or her expectation of privacy, viewed objectively, was justifiable under the circumstances. So the court has focused on the objective prong of the Katz test. It has given examples of when a person has exhibited a subjective expectation of privacy. So there's a case of California versus Ciarello. It recognized a person who placed a 10-foot high fence around his property exhibited a subjective expectation of privacy. Another case, the court held that a person had a subjective expectation of privacy in a double-locked foot locker. But the court has also held the defendant did not have a reasonable expectation of privacy in the purse of an acquaintance that he had known for only a few days and to which others had access. Essentially, an inquiry into a person's subjective expectation of privacy asks whether the person manifested the belief that he or she was keeping something private rather than the mere hope that it remained private. Now, no single factor determines whether a person has exhibited a subjective expectation of privacy that society is prepared to accept as reasonable. However, the court has drawn a firm line at people's reasonable expectation of privacy in their homes. Okay? Court has also examined the severity of the government's intrusion to determine whether the defendant had an objectively reasonable subjective expectation of privacy. In one case, the court held that a police helicopter flying over a home that revealed no intimate details inside the home and created no undue noise, wind, dust, or threat of injury did not violate an objective expectation of privacy. Finally, in what has become known as a third-party doctrine, and most relevant here, the court has held that a person has no reasonable expectation of privacy in information that he or she voluntarily turns over to third parties. By voluntarily turning the information over, a person takes the risk that the information will end up in the hands of the government. So, of course, not all government actions are invasive enough to implicate the Fourth Amendment, but the court goes on to talk about this, but it boils down to, okay, and they spend 5 more pages explaining this, but I can sum it up for you. This person is using an app. The app is on their phone. On the permissions that they clicked or signed or assented to by using the app, they said that we're going to let the app people get information from me and my phone. And it's going to do that for other people also. And now most people would say, I understand they do that, but they're doing that so people can connect and communicate and all that stuff. Doesn't matter the purpose. The point is that you've consented to give up that information to a third party. And this is not the government, okay? It's just a third party. It's a company, Lehto, okay? So you've consented for Lehto to gather information off of your phone. And they're gathering that information, and they're using it at their end. So when the police come along and go, we know this person's got this app on their phone, because that's how they were communicating with the victim, that means that Lehto must have all the data we're looking for that will identify that person. And they go to Lehto and they drop the subpoena on them. And notice that it's one thing to use a subpoena, it's another thing to use a warrant. So There's a statute in Ohio which allows law enforcement to subpoena witnesses. And a subpoena merely means that I can name somebody or something that somebody has, and I know who that person is, and then I serve the subpoena on that person and say, I need that information. But it doesn't have to be signed off by a magistrate based on probable cause, which a warrant would need to be. So this person here, the officer who got this subpoena, probably couldn't have gotten a warrant based on the information he had. But he could get the subpoena, which would get the information, which they would then use to get the warrant. And so this is an interesting case in this day and age because there are so many apps on your phone that have so much information. And so mapping apps, all the social media apps, and so on. And so your phone knows more about you than anybody else on the face of this planet. And I assure you that's true. I'm not being, it's not hyperbole. That is literally true. Because there's a good chance that your phone knows everywhere you were yesterday, at least if you brought your phone with you. And so when you start thinking about that, oh, so where was I 4 days ago? Does my phone know? Well, I'm being a little facetious when I say the phone. It's not the phone, it's the apps on your phone. But the phone is what enables all that. And so we've seen the shows on television where they caught people because they were carrying their phones on them when they committed a crime. And so here, the person they were looking for had used this app, and they know where the app was used. So at that point, if the information has been gathered by this third party to have the information, which they did. And the court's saying, if you want to keep your information private, you can't give it away to third parties. And in the old days, that was usually information that you handed to somebody, or you spoke it to them over the phone or something, or you faxed to them. But nowadays, your phone is narking on you constantly, 24 hours a day, 7 days a week. And that information is going to all kinds of third parties. And so somewhere down the road, it very well could be that the police drop a subpoena on one of the companies that has an app on your phone, wanting to know more about where you were on a particular day. And then get the information, in some states, with a subpoena and not a warrant. So it's an interesting case. I wouldn't be surprised if it goes up to the U.S. Supreme Court. There's a lot of things that could keep that from happening, but I wouldn't be surprised if they tried, because it's a certainly modern question to ask about this, and this can become more and more relevant because a lot of people who were told recently that your phone is tracking you, your apps are tracking you, companies are tracking you using your phone and your apps. They're watching you, they're monitoring you, they're observing your habits, they're trying to sell you stuff. Most people go, it's just commercial stuff, I'm not really that worried about it. Oh, but this is the back door the government uses. See, if the government wanted to get into your phone, they'd need a warrant. But if your phone's giving information up to third parties, they just need a subpoena. The subpoena, easy to get. Warrant, a little more difficult. So it's a fascinating case. Like I said, it's 12 pages long. There's some, whoa, who put that there? There's some great discussions about privacy and expectation thereof. But the case is DIAW, state versus DIAW. Diao, I guess? I'm not sure. And it literally just got handed down the last couple days. And you can check that case out. In fact, I'll put a link to the case in the description below the video. Nick, thanks for sending that. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. I know you believe you understand what you think I said, but I'm not sure you realize that what you heard is not what I meant.